Alright, continuing 100 Statute 1678, Public Law 94999, October 7th, 1986. Superended Refund Recovery Act, Section 122 Settlement. New section Title 1 circulated with the demand of the Act with filing new Section 121. Settlements 122, Section 122 Settlements. Authority to enter with agreements, friends, discreet. They may enter the agreement with any person, including the owner, operative of the facility, that would relieve the substantial threat of release emanates with any other potential responsible person performing a response action, including any of the described 104D and B, the president determined if the action was done properly by the person when the practice, in the public interest determined by the president of the president shall act as a facility of the agreement with the section within the area of the public interest consistent with the national contingency plan in order to expedite effectively remedial action, minimize litigation. President decide not to use the procedure with the action of the president shall notify the written potential responsible parties facilities of the decision reason why the use of the property for the appropriate decision of President may to use not to use the procedure for the section not subject to the judicial review agreements with the potential responsible parties makes funding of the agreement under the section made to provide with the president reimbursement of the party for the agreement of the fund of the interest of the certain call for the activities under agreement with the parties have agreed with the perform the president have agreed with the comments and the case of the president provide with the reimbursement of the president shall make all responsible efforts to recover the amount of the reimbursement under section 107 under the relevant authorities. Reviewability. The president's decision regarding the availability of the funding financing under subsection shall not be the subject of the judicial review under subsection D. Retention of funds. Is it important to of the agreement the president with the carrying out of any act for the party for the paying amount of the president notwithstanding any other provision law for the retaining such of the amount for the purpose of the carrying out of the agreement. Future obligation for the fund, but then gave the complete with the remedial action pursuant with the agreement that described in the paragraph 1 of the fund subject for the obligation for the subsequent with the remedial action, same facility, but only with the extent of the subsequent action necessary for the reach of the failure above original remedial action. The obligation shall proportionally equal to not exceed the proportion contributed to the fund. The original media action with the funds, the obligation for the human mutual action may be fund expenditure through the payment of following settlements, enforcement action parties who were not signatories of the original agreement. Effect of the agreement. Liability. Whenever the president have the the agreement with the section liability down to the act with each of the part of the agreement, include with the aim of the future liability, statement of the arising of the relief of the limited release or threatened relief of the subject of the agreement, such as the limited provide with the agreement, the equivalent of the not to sue with the accord with the subsection after the company not with the may provide with the liability of the United States with the settling potential responsibility part of the agreement is not limited to the same proportion of establishing in the original settlement of the agreement, and the section shall the limited otherwise effectively the authority of the court review the consent the decree in the process of the subsection inconvenient and not sue with the containment of the agreement under section determine the extent with the liability party for the agreement but limited pursuant to the covenant not to sue with the not to sue president guide with the principle of more with a complete covenant the not to sue shall provide with more permanent remedial action on such parties. Actions against other person agreement have the may be entered for the section president made any action under section 106 with the bank against any other person who is not party of the agreement with the party of the submitting a proposal under section A, E, 2, B, but that has expired nothing in the section has been constructed in any other found with the liability with the name of the person 106 107 then require respect for the name of the call of the damage and not include the agreement of the authority with the president maintaining the action under the action against any of the person not part of the agreement enforcement clean up of the agreement the consent with the degree whenever the president enters an agreement under the section potentially responsible party respect for the remedial action on section 106 with the following personal approval of the agreement of the Attorney General except for the otherwise provided the certain administrative settlement of the referred to subsequent G with this agreement with an appropriate United States District Court consent decree with the president does need not to meet any finding regarding an imminent substantial endangerment of the public health or the environmental connection with such arrangement of the environmental consent of the decree. In fact, for the entry of the aim of the consent decree with the subsection construct with the knowledge of the part of the relief of the right and relief of the constitute with the imminent substantial endangerment of the public health, the welfare of the environment, except for the otherwise provided the federal rules of evidence participating aim of the part of the under the section shall not construct the administrative liability aim of the purpose in fact with the participation shall not be admissible. Judicial administrative procedure that include the subsequent proceeding on sections of structure of the president may pass with consent with the deciding so that entrance of the degree of the compliance with the decree determining the agreement with the pursuing the section shall not be considered with an admission liability for any purpose. Public participation. Filing proposed judgment at least 30 days of the final judgment and under the paragraph 1 of the proposed judgment filled with the core of the opportunity to comment. The Attorney General should provide the opportunity person not named the person but the action of the command with the proposed judgment before entering the court of the final judgment. The Attorney General should consider file with the court written commence the review of the allegation relating to the proposed judgment, Attorney General with the withdrawal of the withholding proposed judgment with the comment review of the allegation concerning the judgment is fact that is consideration and inadequate indicate the proposed judgment appropriate, improper, adequate, and whenever the president entered into the agreement and section of the potential responsible party with respect to the action of the 104B of the president shall issue the end in order the enter of the decree of the setting with the obligations of the party of the United States District with the relief of the threat and relief of the occurs, may enforce other order, decrees, special notice, and procedures. Notice when the president determines that the period of the negotiation and subsection of the facility with agreement with the potential responsible party for the taking of response action, including action that is described in section 104B, shall be expected out of the remedial action president shall notify the all such party provide the information concerning the following of the name of the judge for the potential responsible, including the owner's operative of the other person, section 178A, with the extent of the information available to the volume of the non-nature substance contributed to the end potential responsible party, identifying the facility, ranking of the volume of the substantial facility, with the extent of the information available. The president shall make the information referred to in this paragraph available to advance of the notes paragraph at the bottom of the request of potential responsible party in accordance with the procedure provided with the present provision in subsection F1 for regarding protection of the copy of the information provided with the paragraph of the disclosure information general of the president under the section to the person of the Congress, other than Congress, any of the authorized the committee with their subject to the privilege protection provided by law, included by the other attorney work product not contained with the paragraph of the other provision of the act shall be constructed, interpreted, and applied with the diminishing required of the disclosure information under the provisions of the other federal state laws. Alright, negotiation, monetary and except for the provided subsequent subsection of the president of the commenced action over the taking the action from the 106-120 with the provided notice of information with the subsection respectively of such action that provided the subsection of the president may consent to the remedial action by remedial investigation feasible study under section 104B with the 90 days after the notice of the information over the subsection respect to such action the president of the command of the additional study of the investigation authorized under section 104B with include the remedial design under the negotiation period proposal to receive the notice information on paragraph 1 of the subsection respectively under section 106 shall have 60 days of the day of the receipt of the notice of the proposal of the president understanding the financing the action with the section 106 of the president receive the notice of the information on paragraph 1 of the subsection respectively the action under section of the 104B with the 60 days of the receipt of the stuff of the notice of the president take the financial action 104B. Additional parties in addition with the potential responsible party identified with the negotiation and appear with the agreement with the enter under the subsection concerning the relief and the threat and relief of the president bringing the additional part with the negotiation entering the separate agreement in such party preliminary allocation responsibility in general the president shall develop the guidelines preparing non-bidding preliminary allocation of the responsible developing guidelines for the president with including the fact the president considering the relevant value toxicity mobility strengths over the evidence ability to pay the legislative restrict the public interest can coordinate with the presidential value of the inequities aggravating factors would expedite this settlements under the section remedial action power permit the president make completely remedial investigation feasible study provide non-binding preliminary allocation responsibility allocate with the percentage of the total of the response among the potential responsibilities of the facility. B. Collection of information. The collection of information necessary appropriate to perform the allocation for the subparagraph the otherwise implementing section of the president may subpoena require the attending of the testimony witness the production of the report paper the documentaries answers of the question out of the information president deemed necessary with the witness should be paid in the same fee with the mileage and or paid with the witness of the court of the United States and event the contempt the value of the refusal of the no person to obey the subpoena to court in the United States for revenue venue of the property of the child of the jurisdiction over the to order and instruct to comply with the subpoena failure to obey order with the court punishable with the court or contempt thereof. Effect of the non-binding preliminary allocation responsibility admissible the evidence of the proceeding of no court shall the jurisdiction review the non-binding preliminary allocation responsibility non-binding preliminary allocation of the responsibility of the non-considered appointment of the other statement of the visible harm or causation cost include with the president of the producing the non-binding preliminary allocation responsible should be reimbursed by with the responsible aware of the officer is expected by the president with the officer under the section of the cost shall be constructed considered cost response to the response. Decision effective the offer. The president with the discretion had provided the non-binding preliminary allocation responsibility potential responsible to have the made with the substantial providing responsible to the president with the rejects and reasons for rejection shall be provided with a written explanation. President decision rejected shall not be the subject of the judicial review. Failure to propose. President determined the good faith of the proposal to undertake the financial action with this 106 did not submit with the 60-day provision notice for the pursuant of the subsection of the president of thereafter to commence an action with the 104A to take with an action again for the aim with the person 106A of this act. The president determined the good faith of the proposal to undertake the financial action with the 104B with the has not submitted the 60-day of the provision notice of the pursuant of the subsection the president may thereafter commence action with the 104B. Significant threat. Nothing in subsection with the president authority to undertake the response of the enforcement action regarding the significant threat, public health, environment, negotiation period establishment of the subsection. Inconsistent response action, either with the president of the potential responsible party pursuant to the administrative or with the consent decree of this act initiated with the remedial investigation feasible study of the particular with the facility under this act, no potential responsible party may undertake the remedial action of the facility unless this remedial action has been authorized by the president. Covenants not to sue. The discretion covenant for the president may in his discretion provide any person with the covenant not to sue the concentration liability of the United States under this act, including the future liability and resulting in the relief of the threat and relief of the hazard substance of the draft of the remedial action wherever the action on-site or off-site, each of the upon condition. Covenant not to sue the public interest, the covenant not to sue the expedited response action consistent with the National Contingency Plan 105 Act. Person full compliance consistent with the degree of the section 106 include this consent that agreed in accordance with the section response with the relief of the threat and release concern of the response action has improved with the president. Special covenant is not to sue in the case that any person with a resident authorized in paragraph 1 of the section to provide the covenant not to sue the portion of the remedial action when involved with the transportation of the disposition hazard waste for the facility meeting the requirements section 3004 C, D, E, F, and G, and M, O, P, and U, and V of the 8005 of the waste, Solid Waste Disposal Act of the President rejected the pro of the remedial action consistent with the National Contingency Plan does not include with such off-site disposition thereafter of off-site disposition, which involve the treatment of the hazard substance with the destroy, the eliminate, with the permanently, with the immobilize, with the hazard consistent with the substance, with the judgment, with the president, with the substance, with the no longer with the president, with the ending, with the currently fear, foreseeable the future, with the risk of the public health, welfare of the environmental, no product treatment, discretion, profit, and significant hazard, public health, or welfare, and all products of themselves. Destroy the containing the man with the shoe, sure with the sandwich product that is not present with the currently foreseeable the future. Significant risk for the public health, the welfare, and environment. The President shall provide with such person the company not to restrict the future liability under the United States with the act future relief of the threat and relief of the habit of the substance of the facility that provide with the covenant not to sue, but not liability under United States under the 106, 107 with respect to the release of the threat and relief of the future time. Requirements of the remedial action to be complete with the covenant with the master to not to sue with the future with the liability of the United States should not affect the President can certify with the remedial action complete within conformity with the requirements of the act facility with such covenants. Factors in assessing the appropriateness of the covenant and sue with the paragraph 1 of the condition include with the covenant and not to sue in the paragraph 1 and 2 of the President should consider with the covenant and condition of the public interest of the basis of such future and the following. Effective the reliability of the media in light of the remedy. Effective the reliability of the remedy in light of the alternative remedy with the facility concerned with the nature of the risk of the remaining and the facility the extent of the performance standard that include within the order decree standard with the response action provided the complete remedy with the facility including the reduction of hazard nature of the substance facility, the extent with which the technology with the remedial action demonstrated effectively, whether funding with the other sources of the found with available additional remedial action that might eventually necessarily facilitate, and whether the remedial action will be carried out with the whole and significant part of the responsible parties themselves. 5. Satisfactory performance. The covenant not to sue with the subsection subject satisfactory with the performance of each of the such party applications are under the agreement or concern. Additional condition with the future reliability except for the proportion remedial action subject with the not to sue in paragraph 2 of the under section G of the relating to the any settlements with the covenant not to sue the person concerning the future liability of the United States, include the exemption of the covenant allowed the President to sue such person concerning the future liability resulting from the relief of the threat and relief of the subject with the covenant subject such liability arises with the except for the condition knowing at the time of the President certified in paragraph 3 of the remedial action has completed with the facility concerning extraordinary circumstances with the President to determine the assessment of the relevant factors, such as the referred in paragraph 4 of the volume for toxicity, mobility, strength of the evidence, ability to play, litigative risk of public interest, coordinate the presidential value, and equities aggravating, not including exemption referred to the paragraph A of the other terms of the condition requirements of the agreement that contain with the covenant not sue with the position to provide a reasonable assurance of the public health environment that will protect the aim of the future and from the facility. The President authorized include the provision of all the future enforcement under Section 106 and 107 of the discretion public of the President necessary for the appropriate to secure the protection of the public health and welfare environment. Are deemed many settlements expedited final settlements whenever the practical public interest determined by the President of the public the President shall properly with the possible final assessment of the potential responsible party administrative of the civil action 106 107 of the settlement involved with the primary portion of the response facility concerning the judgment of the President condition with the either following subparagraph A and B, both following minimal comparison with the other hazards of the facility, amount of the hazard substance contribution on the part of the facility with the toxic hazard effect of the substance contributed by part of the facility, the potential responsible party, owner of the real party of the which the facility is located, did not connect with the permanent regeneration, transportation, storage, and the disposal of the hazard substance facility, did not contribute with the release of the release of the hazard substance facility without any action of the mission. So paragraph B, if it does not apply with the potential responsible party purchase of the real property, the actual constructive knowledge of the property, U with the generation, transportation, storage, treatment, and the disposal of the hazardous substance. Covenant not to sue with the President may provide the covenant not to sue with the respect of the facility with the concern any of the department that enter within settlement under the subsection of the covenant was considered the public interest for the determinants of part F. Expedited agreement. President such settlement, they grant any of the covenant not to sue with the possible present available the information necessary to such for this grant a covenant consent to decree the administrative of the order settlement under the subsection enter within consistent agreement embodied in administrative order setting with the term of the settlement in English case with the total of the response of $500,000 and supplement embodied with administrative order that is issued only prior to the written approval of the Attorney General. The Attorney General is designated but not appointed with the proof that this of the order 30 days of the referral of the order deemed approved of the Attorney General. The Administrator have agreed to extend the time of the District Court with the district in which the release of the threat and release occur with may enforce such administrative orders. Effective agreement part of the with the result of the United States with the subsection shall not be legally claimed the contributed regarding the maintainment of the settlement, but the settlement does not discharge any of the potential responsible parties unless it is determined of the power to reduce the potential liability of others amount of the settlement. Settlements with the other potential responsible parties. Nothing in the subsection construct for the effect of the authority of the President to reach settlements with the other potential responsible parties under this Act. Clause recovery settlement of the authorities. Authority to settle with the head of any of the department agent, the authority undertook with the response action over the acts of the pursuit of the non-contingency plan with the consider the compromise of the settlement of the claim under Section 107 of the Catholic incurred by the United States government claim that has not referred to the Department of Justice and further action. In this case, any facility with the total response cost exceeds $500,000. Any claim with the referred to with the proceeds since with the compromise settled only with written approval of the Attorney General using arbitration in accordance with the regulation of the subsection of the methods settling claim with the United States for the total response cost facility concerned not to exceed $500,000 after cancellation. Attorney General of the Department agency have established public regulation arbitration settlement under the subsection. Recovery of claims. Any person who failed to pay the claim of the settled under the subsection of the Department the agency shall recover the Attorney General to bring this action from the appropriate district recover the amount of such claim, the plus of the cost of the attorney fee with the interest of the day of the settlement. Such action term of the settlement shall not be subject to the review. Claim of the contribution person over the result of not let liability under state with the subsection not liable to claim of the contributed regards addressed in the settlement. Such settlement should not distribute any of the potential liability unless the term of the provider to reduce the potential liability other than the amounts of settlement. Settlement procedure publication federal register release 30 days of the settlement. Any settlement has been arrived through the arbitration may come with the final under subsection H with the subject E with the case of settlement within body of the administrative order. However, the department agent the jurisdiction cannot statement shall publish in the federal register not notice for the proposed statement with the notice for the identify the facility of the party for the proposed statement. The comment for the 30-day period to begin with the publication of the notice under one of the proposed settlement with the head of the department agency. The jurisdiction proposed settlement should provide the opportunity personnel now parties proposed settlement with written comments relating to the proposed settlement. Consideration comment. The head of the department agency consider the comments without filing under the paragraph 2 to determine whether or not to consent. Proposed settlement with may withdraw with the consent of the proposed settlement. Such comments disclose fact for the consideration indicate the proposed settlement inappropriate, improper, adequate. The national resource for the notification, trustee relief, the threat, and relief the head of the subject for the negotiation of the section of the regulated with the damage for the natural resource for the trusteeship of the United States of the President notify the federal natural resource for the trustee the negotiations of the shall incur the participation of the trustee in negotiations. Covenants not to sue with agreement of the section of the may contain with the covenant with the owner section 107A4C for the damage of the natural resource for the trusteeship of the United States resulting in relief of the threat and relief of the hazards of the subject of the agreement with the federal natural resource trustee and agree with Britain to such covenant federal natural resource trustee may agree with the such for the covenant particularly responsible party with the undertaking the appropriate action with necessary to protect the resource of the natural resource for the damage for the of the release of the threat and relief of the hazards of the section of the not applicable vessel. The provision of the section shall not apply with the vessel release from vessels. Civil penalty. The potential of the responsible party with the party with the administrator or consent with the degree and enter with the agreement under the section 120 under this section or section 120 relating to the federal facility with which the party of the agreement under section 120 is able to refuse to comply with any term of the order, decree, with the arrangement of the agreement with the subject of the civil penalty in accordance with section 19. And applicability of the general principles of the law. The consent with the the settlement under section include the covenant do not to sue the provision actually construct with the preclude the otherwise affect with the applicable general principles of the law regarding citing a signed modification consistent with the decree with the other settlements. Contribution section 308 circular with the amendment with the adding with the following and there if the administrative civil under section 122 with the effect of limiting any of the person right with the obtainment of the contribution from any of the party of the any sub of the settlement if the effect of the limitation would constitute the taking without the Constitution violation. Fifth Amendment of the Constitution of the United States the law person shall not be entitled under the United States to recover compensation from the United States such taken in any such case and such limitation retained obtained contribution shall be treated with that have no force and effect. Section 123, reimbursement of the local government. Title 1, circular with the amending with the following after the Section 122, reimbursement of local government. Application, general purpose of the local government policy. Division, effect with the relief of the threatening, relief of the benefit facility may apply with the president for the reimbursement of the under section reimbursement temporarily emergency measure for the president of the authorized of the reimbursement local need authorized expense for the occurred before and after the enactment of Superfund amendment to the Reauthorization Act of 1980 for the carrying out of the total or temporary emergency measure for the necessary to prevent the mitigation of injury with the human health of the environment associated with the relief of the threatened release of any hazardous substance, pollutant, contaminant. Some of the such measures may include where the appropriate security, fencing, and limited access the response, fire explosion, other measures for the required immediate response at local level. The local findings not supplemented with the reimbursement under the section shall not be supplemented. The local fund is not provided with the response amount of the amount of reimbursement. Any of the local authority subsection may not exceed $25,000 single amount of the reimbursement under the section in respect of the single facility, not limited to the units of the local government that have the jurisdiction, public civil division in which facility located. Procedure reimbursement authorized pursuant to the section within accordance with the rules promulgated with the administrative 1 year after the enactment of the superfunded amendment to the Reauthorization Act of 1986. Methane recovery, generally Title 1, Section 124. Methane recovery, generally Title 1, circular with the amending of the following with the new Section 123. Methane recovery, in general, the cave facility with the equipment with the recovery, the processively include the recirculation condensation. Methane has been installed for the purpose of the act. Owner and operator of the equipment shall not be considered the owner and operator defined in Section 101.20 with respect to the such facility. The owner and operator shall have the equipment with consider the range of the disposable treatment and if it has something such facility pursuant to Section 107 of this act. The owner and operator of the trust equipment shall not be subject to any of the action 106 with respect to the facility. Exemption subsection does not apply with respect to the relief of the threat and relief of the hazardous substance from the facility described in subsection A with either following circumstance for the relief of the threat and relief of the primarily cover the activity of the owner and operator of the equipment described in subsection A. The owner and operator of such equipment would be covered in paragraph 1, 2, 3, and 4 with the subsection A with the section 107 of the respect of the for the relief, threat, and relief of the, if he were not the owner and operator of the such equipment and gave it the relief of the threat and relief that referred to the paragraph 1 of the owner and operator equipment described in the subsection of the liable act of the owner the cost of the damage of the preliminary cost of this activity, the owner and operator regulation of the solid waste disposal act and left the administrative environmental protection agency probably gave the regulation of the subtitle of the solid waste disposal act with the addressing extraction waste of the landfill such problem with the process of the recovering methane. Instead of the landfill's owner of the operator equipment that recovered the methane landfill shall redeem the managing, generating, transporting, treating, storage, disposing of hazardous liquid waste with the meaning of the subtitle of the adequacy hydrocarbon phase, condensating any other waste material removed of the gas, recover the liquid landfill meet with the character of the identified under section 3001 of the subpart solid waste disposal act of the proceeding systems. If it does not apply with any of the such condensating favor the other waste of the material shall deem that has the waste owner, but the subtitle shall be regulated accordingly. Our section 125, certain special study that is circular with amendment with adding the following new section of the way for the provision of hazard ranking system. The section shall apply with the facility not include with the inclusion of the national priority list, which contain substantial volume of the waste described in the 3001 B3A1 of the Solid Waste Disposal Act. If the issue is practical, the president of the revive of the hazard ranking system in effect with the national contingency plan with respect to the facility in which the measure the assure the appropriate conservation each of the following site specific character of the quantity of the toxicity concentration hazard of the concept of the presence of the special waste comparison there with the other waste standard of the other and potential for the other such as the constitute of the environment, the degree of the risk of the health, the human health of the environmental provoke and constitute the inclusion prohibited to have the rankings if it is required with the section present but not include the national priority list any facility with a substantial volume with the described in section 3001 B3A1 of the Solid Waste Disposal Act based for the evaluation principle with the volumes of such waste for the concentration that have the constitute of the such waste, nothing in section with the contributor of the president authority, including any of the facility with the national priority list based for the president of the other substances of the facility, extra for the other authority of the act with respect to the other substances. 126. Worker protection standard. The promulgation 1 year after the day of the enactment of the section secretary of labor pursuant to the section 6 of the OSHA 1970 with the promulgating standard. Health of the air safety protection employed with engaged hazard waste operation proposed standard with the secretary of labor the show this proposed regulations such as the standard that include but not limited to the following worker protection provisions. Site analysis requiring formal hazard analysis of the development site specification worker training protection training requirements for contractors to provide initial routine training work before such works are permitted to engage hazard waste operation which would expose them to toxic substance. Medical service the program and regular medical examination monitoring surveillance of workers engaged in the hazard waste operation which expose them to substances protective equipment requirements that appropriate personal protective equipment, clothing, respirator work, and the hazardous waste operation, emergency control, engineering controls requirements for the engineering controls concerning the use of the equipment and exposure for the worker engaged in the hazardous waste operation. Maximum exposure limit requirement for the maximum exposure limitation of the worker and gave the hazard wave to operation, including the nature and necessary monitoring and assessment of the receive that informational program and inform the worker that engaged for the hazard waste operation nature for the degree of the toxic exposure limited and likely the result of the hazard waste operation, handling, acquiring, handling, transportation, labeling, disposal of hazard waste, new technology program with introducing new equipment, the technology to maintain the worker protection, 10 decontamination procedure of the decontamination 11 emergency response requirement, emergency response protection worker to engage in hazard waste operations. Your final regulation of the under subsection A shall take the effect of 1 year after the date of the promulgation. Final regulations of the subsection A of the Secretary of Labor shall include the provision listed in paragraph 1 through 11 of the subsection B, with the under subsection the Secretary determined the evidence of the public record considered whole does not support inclusion of any such provisions. Specific training standards, off-site instruction and field experience. The public with the subsection A would include the training standard requiring the general site worker such for the equipment operative, the general labor with the supervised personnel, but then gave the hazard substance removal of the other activities exposed to the potential exposure. Such work to hazardous substances receive the 40-minute or minimum 40-hour with the initial instruction of the officer over the minimum 3 days with the actual field with the experience with the direct supervision training experience, supervise the time assignment of the requirements of the preceding sentence, if it does not apply with the general site with the workers who receive the equivalent of the training working or would may be excused, suppose unique special have to provide additional training. Training supervisor. The standard properly given the under subsection shall include the training standard required by the on-site name for the supervisor directly responsible for the hazard waste operation. The foreman receive the same of the training with the general site with the workers says that the paragraph 1 subsection at least 8 additional hours of specialized training managing hazard waste operation requirements of the proceeding sentence will not apply with the person to receive the equivalent of such training certification enforcement of the standard with the training standard with the certification provision with the certified with the general site with the worker with the on-site manager with the supervision have received the specified training shall prohibit the individual who has not received the specified training engaging hazard waste operation covered in the standard. The training emergency response personnel officer for the training standard set forth in the requirements of training. The worker responsible for responding to an emergency situation must be exposed to the toxic substance, carrying out the other responsibility. Interim regulation, Secretary of Labor shall determine the final regulation under Section 60 after the enactment of the section with which shall provide the no less protection under the section of the workers employed with the contractor emergency response work with the protection contained within Environmental Protection Agency Manual 1981 Health and Safety Requirements Employee engaged in field activities. And existing for the Occupational Safety Health Act of the 1975 and the 19 subpart C of the 1926 Title 29 Code Federal Regulation shall determine the final regulation title effective upon issuance which shall apply with the final regulation become effectively under subsection C. Covered in certain state and local employed with no later than 90 days after publication final regulation subsection the administrator of the public with the public with the Secretary of Law Labor under subsection standard probably given the under section shall apply to the employee state local governments from the state with which it does not affect in each state which does not affect the approved state plan under 18 Occupational Safety Health Act of 1970 providing the standard for the health and safety protection employee engaged in the hazard waste operation. Or your grant program. Grant purpose for the grant for the training education over the worker that may be engaged with the activity regulated with the hazard waste removal and containment that emergency response may be under the subsection administrative grants under subsection administered for the National Institute of Environmental Health Sciences. Grant recipients shall be awarded nonprofit or to nonprofit organizations demonstrating experience with the implementing operating work health and safety training and education program, demonstrate the ability to reach and involve with the training program target population of the workers who are willing to engage hazard waste removal and contaminate emergency response operations. All right, section 127. Your liability on limits for the ocean incineration vessels. The definition of the incineration vessel is section 101 circular with the amendment of the following in paragraph 37. Term incineration vessel meaning any vessel carrying hazardous for the purpose of the incineration of the substance such along with the substance residue with the substance on board. Liability section 107 the amendment is followed by subsection A3 and amendment with the inserting incineration vessel after facility. Section A4 is amendment with the inserting incineration vessel after facility. Section A with the subsection amendment with the incineration after the incineration vessel after vessel. Subpart B with the subsection amendment with the insertion after the other incineration vessels after other vessel. Subpart D section C1 amendment with the insertion after any incineration vessel before any facility. Final financial responsibility section 108 circular with the amendment is followed. Paragraph 1 amendment with the insertion covered the liability prescribed in paragraph 1 of the 107 of this act in which there's greater than a new paragraph that reads as follows. The additional financial responsibility provision paragraph 1 of the president shall require additional evidence of financial responsibility incineration vessels such as amount with the cover of the liability reckoned of the president of the deemed appropriate to take into account with the potential rate of the proposed incineration, transportation, incineration, and the effect deemed relevant to saving clause of section 106 of the Maritime Protection Resource Sanctuary Act of 1972 amended with adding the following new section at the end of their segment called the nothing in the actual restricted effect with the notifying the rights of any of the persons, same damages and enforcement any of these limitations, state law, but including state common law, to seek the damage for the other federal law, the maritime tort law, the result of the non-compliance with any of the requirement act to permit the under this Act, Maritime Tort, Section 107A, the circle of the amendment inserting under Maritime Tort Law, and after this section, inserting the before period of the absence of any other physical damage, priority, interest, and claim. Title 2, Miscellaneous Provisions.